Moving on, I would like to discuss the laws applicable for films. In the area of films, broadly there have been two major media laws, Cinematograph Act 1952 and Cinematograph Act Rules 1983. The following are needed to comply with the laws pertaining to films: guidelines for import of films, guidelines for import of cinematographed films and other films, revised guidelines for shooting feature films in India by foreign nationals and co-productions, guidelines to certify films, policy framed for certification of films for film festivals, Cinematograph Act 1952 and Cinematograph Rules 1983. Knowing of these laws is utmost importance when it comes to film making in India. The pattern of examination of films, certificate of films and appeal in the light of board's certification should be knowledgeable on the part of every filmmaker in India. Examination of films. Any individual wants to show any film shall have to apply in a particular format of application to the board, and board shall examine the film to issue a certificate. No action shall be taken by the board except after giving an opportunity to the applicant for representing his views in the matter. The board may consult in such a manner as may be prescribed any advisory panel in respect of the film for which an application for a certificate has been made. It shall be the duty of each and every such advisory panel, whether acting as a body or in committees as may be provided in the rules made in this behalf, to examine the film and to make such recommendations to the board as it thinks fit. Certification of films. After examining a film or having it examined in the prescribed manner, the board considers what kind of certificate U, A, U or A and S. In addition to the certification of the above, the board may decline to certify a film. Appeal. A person who is not satisfied with the board certificate on the following can appeal: declining to grant a certificate, or granting only an A certificate, granting only a S certificate, or granting only a UA certificate, or directing the applicant to carry out any exceptions or modifications may within 30 days from the date of such order prefer an appeal to the tribunal. Now, let us examine labor related laws in India. Suffice to say, there have been certain laws applicable to people working in media industries. However, some laws have been enacted to regulate the conditions of the employees working in media sectors. Few have been discussed in the light of welfare of journalists. The Working Journalist and Other Newspaper Employees and Miscellaneous Provisions Act 1955 and the Working Journalist and Miscellaneous Provisions Rules 1957. Working journalist is a person who is a journalist whose job is of an editor or leader writer, news editor, sub-editor, feature writer, copy tester, reporter, correspondent, cartoonist, news photographer and proofreader. This is an act to regulate the conditions of service of working journalists and other persons employed in newspaper establishment. It applies to all the states in India except Jammu and Kashmir. So far as the wages of or remuneration are concerned, the act entails fixing or revising rates of wage as per government norms. The act even calls for constituting a wage board whenever required. It is imperative on the part of the central government to make an order in terms of recommendation after receiving any recommendations of the board. In a view to execute this act properly, all assistant labour commissioners of the labour department have been appointed inspectors for applying the enforcement work under the act. The act accommodates the provisions of the Industrial Dispute Act with minor modifications. The period of notice for retrenchment for the editor and other working journalists is 6 months and 3 months respectively. The Employees Provident Fund Act 1952 has been incorporated in the act to maintain the welfare of the journalist. A journalist is not allowed to work more than 144 hours in 4 consecutive weeks. He or she is allowed to take 10 holidays in a year with other compensatory holidays conditionally applied. Now, I will discuss about intellectual property rights in India. Intellectual property rights indicate to a brand, invention, design or any kind of creativity for which a person or business possesses the legal rights. Broadly, the IP includes copyright, patent, designs and trademarks. Mostly, the main intellectual property rights legislation related to media sector is the Copyright Act of 1957 and Copyright Rules 1958 and the International Copyright Order 1999. The Copyright Act 1957 rules the subject of copyright law in Copyright Act covers original literature work, original dramatic work, original musical work, original artistic work, cinematograph, films, sound recording and computer program. This law applied to the rights of reproduction of the work, communication for the work to the public, adaptation and translation of the work. The scope and duration of protection provided under copyright law depends on the nature of the work. The Act has clearly announced the duration of copyright protection in India. The duration of copyright protection under this Act for literary, dramatic, musical and artistic works is lifetime of the author plus 60 years from the beginning of the calendar year next following the year in which author dies. The duration of copyright protection for anonymous and pseudonymous works, posthumous work, cinematograph films, sound records, government work, public undertakings, international agencies and photograph is until 60 years from the beginning of the calendar years next following the year in which the work is first published. The Act covers aspect of ownership. As per norms, the author is considered as the first owner of the copyright. However, if there is an association of contract of service or apprenticeships, the employer is treated as first owner of copyright without any agreement. The existence of joint authorship is there in section 2Z of the Act. There are certain exceptions to copyright infringement in India. The Act permits fair dealing with any copyrighted work for certain specifically mentioned purposes, certain specific activities enumerated in the statute. The glaring instance of exception to copyright can be cited here. In 2016, the Delhi High Court made an exception of Delhi University's Rameswari Photography Service Shop selling photocopies of chapters from academic textbooks, stated that that was not infringing on their publisher's copyright. However, in the same year, the ruling was reversed and taken back to court, indicating tribal issues in the case. In the light of bringing remedies against copyright infringement of the Copyright Act 1957 affords administrative remedies, civil remedies and criminal remedies. In order to lessen the proliferation of piracy in India, viewing, downloading, exhibition and duplication of the certain contents, URLs invites legal issues under sections 63, 63A, 65 and 65A of the Copyright Act. Intellectual property can be discussed in the profession of photography, image theft, photo plagiarism, photo manipulation, in documentary news, reportage, portrait and fashion photography, nature photography, drone photography, the ethics of photography, competitions and ethics of feeding wildlife have grossly invited issues in IP rights. In news media, sometimes the television channels disseminate the images and footage which are in the doctored form, aiming to raise the television rating point.